Thank you, Mr. Nadler. Mr. Jordan, I believe, defers to Mr. McClintock. Mr. McClintock, you be next then.
Well, thank you, Mr. Chairman. Mr. Schweikert, does qualified immunity only apply to the police, or does it apply to all public officials?
Thank you, Congressman. Qualified immunity applies across the board to all public officials who might be sued under Section 1980.
So, for example, Lois Lerner violated the rights of thousands of Tea Party members by abusing the authority of the Internal Revenue Service to go after them for their political views. Can she be sued by those victims of her bad actions?
In the context of federal officials, they are entitled to qualified immunity. There are also additional difficulties in suing them under the Bivens Doctrine because
let's just stick to qualified. Qualified immunity protects people like Lois Lerner from the effect of their actions, correct?
It does, yes.
Could Michael Flynn sue Andrew McCabe for the violation of his civil rights under this doctrine of qualified immunity?
Qualified immunity would apply in any such suit.
I think it's unfortunate this issue's been entangled with the left's attacks on law enforcement and the rule of law. The Fresno case that you mentioned involving the theft of coins seized by obviously crooked police officers. Now, you say they were shielded from the effect of from being sued by the victim by the doctrine of qualified immunity. They still broke the law, though, didn't they? They still stole the coins, didn't they?
Absolutely, but the fact that they broke the law, even committed a criminal offense, is simply a different question than whether there was clearly established law as to the constitutional violation they committed.
So once they're convicted of that crime, can they be sued by the victim, or are those officers still shielded by qualified immunity?
Even a criminal conviction would be an entirely separate matter. Even a police officer who's convicted of murder for killing someone could still theoretically be protected by qualified immunity.
So the victim would not be able to recover the costs that they had borne.
That's correct.
Because of this constitutional violation. Mr. Johnson, employer liability that Judge Newman proposed seems to make sense. It would assure that there's a remedy for a violation of rights. It assures that individual officers wouldn't face financial ruin, and it gives the local department then an incentive not to tolerate misconduct. Doesn't that make sense?
I think part of it does. Yes, sir. I think that there's already a tremendous incentive on the part of agencies to deter misconduct, completely aside from qualified immunity. Just the attention given by media, by the press, by attorneys, and so forth. There's a tremendous spotlight on law enforcement in the United States, and there has been for several years now, specifically regarding allegations of misconduct. Well, and so I don't.
Marshaling public opinion is one thing, but actually having an avenue that you can take to protect your constitutional rights, that seems to be an important recourse that was established back by the original law in 1871. Mr. Schweikert, is it the 1967 Warren decision that is the root of the problem, or is it the 82 modification on the clearly established standard?
I think the 1982 decision in Harlow versus Fitzgerald is really the core of the problem because it is the clearly established law standard, which is what governs today, and that's the standard that excuses even unreasonable or intentional constitutional violations for the sole reason that there doesn't happen to be a prior judicial decision in that jurisdiction with similar facts.
So if we codified the 1967 Warren test and yet explicitly removed the clearly established standard in the 1982 modification, would that be an improvement, and would that be would that solve the problem?
I think it would be an improvement. I don't think it would solve the problem because that would still leave some circumstances where someone's rights were violated and they're nevertheless left without a remedy. I think a better solution would be a shared liability regime between employers and employees, and simply clarifying that if the individual officer had an actual good faith belief in the legality of what they were doing, then it would simply be the employer who was liable, not the individual. but it's still essential to ensure that anyone whose rights are violated does get a remedy.
Well, I mean, obviously, the maxim is that for every right, there must be a remedy. If you don't have a remedy, then you really don't have the right.
Exactly.
Thank you.
Thank you, Mr. McClintock.